the model we're currently using is mirrored on the UK. The regulations that will be issued shortly for consultation are going to pretty much say what the advisory that the FRA issued says. So in our advisory, we essentially said, here's the new regime. We highlighted that came into effect on the 2nd of January. So in addition to filing a SAR, need the FRA's consent. We essentially set out some wording that said, look, hey, in addition to filing your great SAR with all the details of how you've arrived at the point of filing a SAR.
So there is a key point there to make that distinction so that between just a SAR versus a DAML SAR that's been indicated on the filing.
On the filing. And then lastly, when you file and in your reason for suspicion section, you need to specify why you were seeking a DAML and what you're seeking it for.
So it's the transaction that you're about to enter into want to engage in.
Yeah, whatever. Typically a transaction, whatever it is. So, even you may have set out what you're going to do in your SAR, but you do need to specifically ask for the defense that you're seeking.
So I understand the regime will work that a filer will file the SAR, and then from the following day, there's a 7-day sort of moratorium period where the filer should not enter into that transaction and should wait for the authority to look at the SAR, the DAML, I should say, and to go through its assessment process, then either provide consent or not. And that if you don't hear anything after the end of the 7-day period, then it's sort of deemed consent. And I guess if an entity wanted to expedite a DAML, that would indicate the urgency maybe to you that we need this to be focused on as soon as possible, and then either it's a yes or a no. And if you say no to a transaction, that then triggers a 30-day moratorium period that, as you've already described, probably allows the additional agencies to receive reports from the FRA and to then commence their own investigations. Is that sort of correct process?
It is. There's a 7-day notice period, and as you've said, during the 7 working days, I should specify seven working day notice period, commencing on I think the day after the DAML is received by the FRA. Right. So during that period, I'll have assessed the DAML request. The authority for granting or refusing consent sits with the director of the FRA.
Right, so you're in the hot seat.
So I'm in the hot seat. So typically, once I've done that assessment, I think working backwards, I'm not going to refuse consent unless law enforcement has confirmed to me that it's a matter they want to pursue. Right. So when the DAML initially comes in, it's assessed by me. If I think it's a matter I need to bring law enforcement on, and I've been in post 8.5 years, so I think that I have some inkling about what might be pursued or not pursued. I'll then refer the matter, or I'll liaise with the relevant law enforcement agency. I'll go with SIBFI and say to SIBFI, hey, this is what we've been told. The reporting entity has requested a DAML. What say you?
Right.
And I'll say the notice period expires on this date, failing which they'll be deemed to have consent. And then law enforcement will engage with me, and they'll make a decision and let me know what they'd like to do. So the majority of DAMLs that have been filed are matters that I think I'm able to make a decision on. We have made a few referrals to SIBFI already, and during that 7-day notice period, the decision was taken that they were minded to grant consent, and therefore consent was granted. So we're coming up on the end of month 2, and I can confirm that there have been no refusals of consent yet.
Right, and the way you're seeing that operate in practice is essentially just through expiry of the 7 days?
The majority of them have been through expiry of the 7 days. There are a few that I've gone back and granted consent. So there's a variety of situations there. You talked about the urgency and stressing that, and you can do that. And then if it's urgent, I encourage people to pick up the phone and call me and talk through it. The risk there, Patrick, is that you know how it is. If you tell someone that if you say it's urgent, it'll go to the top of the queue, then everybody has the potential to say it's urgent. So I've said to people, well, look, if everybody says it's urgent, then we've already derailed the system.
Yeah.
So if everything's urgent, nothing's urgent in my world.
And so I guess to ask the obvious question, which is that you've sort of described that the DAML needs to be specific enough to a particular transaction. I mean, obviously, if it's vague and open-ended, then that's going to complicate your job, your process to provide the consent. But the obvious point being, if you say no and refuse, what then is the real risk for the recipient or the filer if they then continue to engage in the transaction?
Well, if consent's been refused, or they haven't gotten consent, or deemed consent hasn't expired and they engage in the activity, I think they're running the very real risk of committing a money laundering offense, which the repercussions for that could be criminal prosecution, could also be huge reputational risk for the reporting entity, and not only them, but the Cayman Islands overall. It could be regulatory fallout. It might be a matter that the regulator would then look at and consider whether an administrative fine is appropriate. So I think entities need to be very mindful of their obligations, and we've specified in the advisory that if you're in the moratorium period, you cannot engage in the activity. As you've said, during the notice period as well, the initial 7-day notice period, you can't partake in the activity that you've requested the defense for until you either get consent or the 7 working days has expired.
Yeah, that makes sense. So I guess in that context, when you've exercised the judgment, as you said, through sort of years of experience, to think that action's going to be taken and you do refuse consent, a person then finds themselves instead in this 30-day moratorium period from the point, I guess, you've told them no, they've received that response.
What do they say?
Yeah, I mean, in this sort of point...
I said to industry, I've got a number of problems on my side of the fence. This isn't one of them, but, I spoke at something yesterday and there was a lot of discussion in the room about, what do I tell my client for 30 days? And in particular, not to commit a tipping off offense. So we had a good discussion, and one of the takeaways, someone mentioned that potentially in other jurisdictions they've amended their tipping off provision so that after a particular time tipping off might fall away. I don't know if that's the case or not, so that's the next little project we're going to look at.
Can that period be extended again? So, for example, if law enforcement are looking at something and they, I know in the UK, I think it can be extended up to about 86 days. So, if a 30-day isn't sufficient period of time for the investigation, is then avenue for that to continue?
That's what the regs are going to. The current draft of the regs that are going to go for consultation include provisions for law enforcement to make an application to the court to extend the moratorium period. So it's identical to the UK provision.
Right, and so then theory as well, if for some reason you didn't hear from law enforcement within 30 days, fairly unlikely it sounds like, on expiry of that period again, is it sort of back to effectively deemed consent at the end of the 30 days?
The FRA's rule is we're processing the SAR because, non-DAML SARs, DAML SAR, it needs to be analysed and processed. The big change is, for us at the moment, is for a DAML SAR, we need to do something within 7 working days.
Yeah.
So, but it doesn't really change our analysis or even how we're prioritizing cases. So, for example, we might have a case that we give a priority 3, but there's still a DAML request involved. But the nature of the case doesn't, because it's a DAML request, it doesn't automatically escalate to priority 1.
Right.
So what we have to do is assess, allocate, and we're going to analyze as per our operating procedures. If there's a DAML component, that will be dealt with predominantly by me.
Right.
And once consent's either been granted or deemed or even refused, once it's refused, it's really a law enforcement matter. Because as I've said, I'm only going to refuse consent.
You are the gatekeeper for the 7 days, and then
if consent is refused, it's because law enforcement has indicated to me that this is a matter that they're interested in or going to pursue. Then it's over to them. I'm sure there'll be ongoing dialogue, but it's up to them then. Once they've commenced their investigation, they're the ones who have to get it done
in that period of time. And I guess this is also
period. And assuming, in the regs will have provisions for them to make applications to court to extend it, and it'll be similar to, they can do that a number of times with the court's blessing.
And this is probably where we almost move more from there's obviously the live concern around the tipping off, but into the sort of additional offence that we've just mentioned about prejudicing an investigation. So I think this sort of comes back to the longer the investigation runs, and I am aware that in certain situations that consent may be given even for law enforcement then just to follow or to trace activity. Some examples in the UK. And so I think, again, it's important that throughout this process, not only the tipping off, but obviously not discussing the potential ongoing nature, or even if consent is given, to then not inform a client or a customer that a SAR or a DAML was filed or that consent was given, because again, an investigation could still be continuing in the background. So you certainly don't want to be in breach of prejudicing that.
Prejudicing an investigation, that section of POCA is not one that we use often or that I'm that familiar with. In preparation for this, I did look at it. But my understanding would then be, if a law enforcement agency is conducting an investigation, typically the party would know that there's an investigation ongoing. They would have likely have been contact from law enforcement. Law enforcement would have likely instructed them on certain things, including maintaining the necessary records. And so depending on the nature of the investigation, because if law enforcement took the decision to, say, interview someone on a caution, then the person on the caution knows there's an investigation.
But as you said, ensuring that you've retained records, etc. You haven't done something that could otherwise...
So again, I think it's an area where it sounds like a cop-out, but you certainly need to seek legal advice.